All right, now we're going to continue building on our Bill of Rights. And today we're going to be looking at the Eighth Amendment, which governs bail, fines, and punishment. And then we're going to step back to consider kind of the broader role of procedural due process throughout the entire criminal justice process. So let's begin with the text of the Eighth Amendment. It says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This amendment is notably concise. It encapsulates kind of three very crucial protections that are designed to limit the government's power to punish individuals within the criminal justice system. Now, the core protections of the Eighth Amendment are the excessive bail clause, which addresses the monetary conditions for pretrial release. And then you have the excessive fines clause, which limits the government's ability to levy any kind of disproportionate monetary penalties. And then you also have the cruel and unusual punishments clause, which is perhaps honestly the most litigated and debated part of the amendment because it governs the severity and the humanity of criminal sentences, particularly the death penalty. Now, as with most of the Bill of Rights protections that we've studied, all three of these Eighth Amendment clauses have been incorporated, and thus they apply with equal force to the state and local governments through the 14th Amendment's Due Process Clause. And again, it's to ensure that these protections against this, overzealous punishment are consistent across all levels of the U.S. justice system, or it's supposed to be. Now, let's examine the first two clauses of the Eighth Amendment. You have the excessive bail and the excessive fines. Now, the excessive bail reads, excessive bail shall not be required. And bail is the money or property that gets pledged to the court to ensure that a defendant who has been released from custody before trial is going to return for their court appearances. So the definition of excessive bail is not it's an unreasonably high bail amount that's not reasonably calculated to ensure that the defendant's appearance at trial will happen. Okay? It's not meant to be punitive before the conviction. Now, the purpose of bail is solely to ensure the defendant's appearance at trial. That's it. Okay? Again, not intended to be a form of pretrial punishment or to deprive the person of liberty indefinitely, but the bail is supposed to reflect the flight risk that's posed by the defendant. Now, it's important to understand that the Eighth Amendment does not guarantee a right to bail. Rather, it means that if a bail is set, it cannot be excessive. So, in certain cases, and it's particularly if it's a serious felony where there's a high flight risk or there's a clear danger, like to the community, then a judge might deny bail altogether. And these denials are generally considered permissible under the Eighth Amendment as long as due process has been afforded to the individual. Okay. So, when setting bail, judges typically will factor in various things, including like the seriousness of the offense, the defendant's ties to the communities, like their family, their employment, their property, things like that. They'll even look at their financial resources, their criminal record, and the perceived flight risk. Now, the second clause states, nor excessive fines imposed. And the definition of an excessive fine is a disproportionate monetary penalty. And this applies not only to fines that get imposed as punishment for a crime, but also to cases where there's civil asset forfeitures. This is where the government is going to seize property that has been allegedly connected to criminal activity. And the value of the forfeited property must not be grossly disproportionate to the gravity of the offense itself. All right. Now, the purpose of the excessive fine clause is to protect property from governmental abuse and to ensure, again, the proportionality in punishment, to prevent the government from using excessive monetary penalties as a means of oppression or confiscation. And the protection is rooted in the English legal history, where excessive fines were considered a tool of the royal tyranny. So for a long time, there was some debate about whether the excessive fines clause, though, did apply to the states. And that question was definitively answered in 2019. And it was the Supreme Court case of Timms versus Indiana, which incorporated the clause against the states. Now, Tyson Thames pleaded guilty in Indiana to charges of drug dealing and the conspiracy to commit theft. And the maximum statutory fine for his drug dealing conviction was $10,000. Now, the state of Indiana did seek a civil forfeiture of his new like Land Rover SUV, which he had just purchased for $42,000, and it was with money that came from an insurance payout. And the state argued that the vehicle was used to facilitate his drug dealing. So they argued that the forfeiture of his $42,000 vehicle for an offense with a maximum fine of $10,000 was an excessive fine under the Eighth Amendment. So the question before the court was, is the excessive fines clause of the Eighth Amendment incorporated against the states by the 14th Amendment's due process clause? And the Supreme Court held that the excessive fines clause is incorporated against the states by the 14th Amendment's due process clause. So the Indiana forfeiture of Tim's vehicle was subject now to the Eighth Amendment's proportionality limits. And Justice Ruth Bader Ginsburg wrote for the majority, and she said that the court conducted a historical analysis. And they found that the protections against excessive fines was a fundamental right that was deeply rooted in the nation's history and tradition. And the court noted that the Magna Carta, the English Bill of Rights, and even early American state constitutions all contained similar protections against excessive fines. And the court determined that the civil asset forfeitures, when they serve at least in part to punish the owner, do fall under the purview of the excessive fines clause. So the state's punitive intent in taking the vehicle was clear. That's regardless of whether the proceeding was labeled as civil or criminal or anything else. So therefore, the value of the forfeited property had to be proportional to the gravity of the offense itself. So the impact that Thames versus Indiana had was significant because it extended this critical check on state and local governments' use of fines and civil asset forfeitures to again ensure that such penalties are not going to be disproportionate to the crime that gets committed and or was committed rather. And it has a particularly important implication for individuals who may have valuable property that gets seized for relatively minor offenses because it provides a new avenue for challenging those forfeitures under the Eighth Amendment. So now let's talk about the most debated and litigated clause of the Eighth Amendment. And that is the cruel and unusual punishments clause. And the text states, nor cruel and unusual punishments inflicted. So the general standard here is that the punishment must not be excessive. And that means it must not go beyond what is justified by any kind of legitimate penological purpose. That's your retribution, deterrence, incapacitation, or rehabilitation. Okay? So the court's interpretation of cruel and unusual has evolved over time, and it reflects what the court calls evolving standards of decency that mark the progress of a maturing society. And the most intense focus of this clause has been on the death penalty. And while the Eighth Amendment explicitly addresses punishments, it does not explicitly ban the use of the death penalty. So the Supreme Court has repeatedly held that the death penalty itself is not inherently unconstitutional when it comes to the crime of murder. Now, its application, though, has been subject to the intense scrutiny. So the standards for the death penalty have shifted significantly, moving away from mandatory death sentences in some jurisdictions to sentences requiring guided discretion. So the first major challenge to the death penalty's application came by way of Furman versus Georgia, which effectively placed a temporary moratorium on executions worldwide in 1972. So the facts of this case actually involves three defendants. One was in Georgia, and I believe the other two were in Texas. And they were sentenced to death for murder and rape. In each case, the jury had broad discretion to impose the death penalty or a lesser sentence, and there was no clear standards guiding their actual decision. So the death sentences were challenged as violating the Eighth Amendment because they were imposed in an arbitrary and capricious manner, often with racial disparities. So the issue before the court was the imposition of the death penalty under those existing statutes in those states unconstitutional because it was applied in this arbitrary and capricious manner, violating the Eighth Amendment and the 14th Amendment. And the Supreme Court held in a very, very narrow 5-4 decision. It was actually a per curiam decision, which means it was unauthored. But it held that the death penalty, as it was then applied under the existing state laws, was unconstitutional. And this decision effectively halted all executions nationwide, as the statutes were deemed to allow for this arbitrary imposition of death sentences. And there was no single majority opinion in this case. Each of the 5 justices in the majority wrote a separate concurring opinion, and the 4 dissenting justices also wrote a separate opinion. And there was still a common thread, though, among the majority, and that was that the death penalty was being imposed in what seemed to be a random, arbitrary, and discriminatory way. Now, Justices Brennan and Marshall argued that the death penalty was inherently cruel and unusual punishment, violating the Eighth Amendment in all circumstances. Now, Justices Stewart, Douglas, and White, however, they did not ban the death penalty itself. Instead, they found the way that it was being applied was unconstitutional because the juries had too much unfettered discretion, and that this was leading to what they called wanton and freakish applications of the death penalty. So Justice Stewart famously said that being sentenced to death under those statutes was cruel and unusual in the same way that being struck by lightning was cruel and unusual. And they were concerned that the death penalty was being imposed disproportionately on racial minorities and the poor, and not necessarily on the worst of the worst crimes. Now, the impact that Furman v. Georgia had was that it didn't declare the death penalty unconstitutional per se, but it did invalidate all existing death penalty statutes in the United States because they allowed this arbitrary imposition. So it led to this temporary moratorium on all executions across the country. So states then responded by enacting new death penalty statutes that were designed to address this arbitrariness concern that was raised by Furman. The new statutes were then challenged in 1976 in Gregg versus Georgia and its companion cases, which effectively reinstated the death penalty. All right, now in response to Furman, Georgia enacted its new death penalty statutes, and they were aimed to provide more objective standards for juries and for appellate review. And these statutes introduced a bifurcated trial process. This means that you had a separate guilt phase and a separate sentencing phase. And it required juries to consider specific aggravating factors. And those are factors that make the crime more severe, like murder that happens during a robbery, and then mitigating circumstances. And those are factors that make it less severe, like perhaps the defendant's youth or the lack of a prior record, before they actually impose the death penalty. And they also mandated automatic appellate review of death sentences by the state's highest court. So the issue before the court was, is the death penalty itself as a form of punishment for murder inherently cruel and unusual in violation of the 8th and 14th Amendments? And did Georgia's new death penalty statutes that were designed to guide the jury and provide for appellate review, did it violate the 8th Amendment? And the Supreme Court held that the death penalty itself is not inherently cruel and unusual punishment. And it found that that Georgia's new death penalty statutes, with that guided discretion and that bifurcated trial process, was constitutional, and it adequately addressed the concerns about the arbitrariness raised in the Furman case. Justice Potter Stewart wrote for the majority, and he reaffirmed that the death penalty itself is not per se unconstitutional. He stated that the punishment of death does not invariably violate the Constitution. The court recognized that the two main goals of capital punishment is retribution, which is society's demand for justice, and then deterrence for preventing new crimes. The key to the new Georgia statute's constitutionality was its procedural safeguards that it put in place. And the first was that bifurcated trial process, where you have the separate trial to determine the guilt, and then a separate sentencing phase if the defendant is found guilty of a capital crime. Then you also have the guided discretion, where the juries are given specific instructions on what aggravating circumstances they must find. For example, a murder committed during another felony. To consider a death penalty. And they must also consider those mitigating circumstances as well. This was aimed to ensure that the death penalty is reserved for the most heinous crimes and culpable offenders. Then you also had the automatic appellate review. So, with all death sentences being automatically reviewed by the state's court, they found that it was enough to ensure that there was consistency and proportionality. Now, the impact here was that Gregg versus Georgia, like I said, effectively reinstated the death penalty in the United States, and it ended that moratorium that had been imposed by Furman. And it established a new framework for constitutional death penalty statutes, again, requiring procedural safeguards to ensure that capital punishment is imposed consistently and fairly. Or so it's supposed to be. Again, I know this is one of those things that we could debate, but it is not supposed to be in an arbitrary and capricious manner. And this led to other states to revise their death penalty laws to conform to now the Gregg framework, which allowed the executions to resume. Now, while Gregg itself did affirm the constitutionality of the death penalty itself, the Supreme Court has subsequently imposed significant limitations on its application, particularly based on characteristics of the offender itself. And again, this reflects that evolving standards of decency that mark the progress of a maturing society that we had already discussed. And the court has recognized that certain classes of offenders have diminished culpability, and thus they cannot be subject to the ultimate penalty. And one of those is the limitation when it comes to offenders with intellectual disabilities. And this was definitively addressed in the Atkins versus Virginia case. So Daryl Atkins was convicted of abduction, armed robbery, and capital murder in Virginia. And during the sentencing phase, a forensic psychologist testified that Atkins was, quote, mentally or mildly mentally retarded. Don't come for me. That was the term that was used at the time. And it is now, commonly referred to as intellectually disabled. But his IQ was determined to be 59, which falls within that range of intellectual disability. And despite this, the jury sentenced him to death. And Atkins appealed, arguing that executing individuals with intellectual disabilities violated the Eighth Amendment's prohibition against cruel and unusual punishment. So the issue was, does the Eighth Amendment's prohibition against cruel and unusual punishment forbid the execution of individuals with intellectual disabilities? And the Supreme Court said, yeah, it does. It found that these executions constituted cruel and unusual punishment. And Justice John Paul Stevens wrote for the majority and said that the decision was primarily based on the concept of evolving standards of decency that was found under the Eighth Amendment. And he said they looked for evidence of a national consensus against executing the intellectually disabled. And he noted that, one, you had a significant and growing number of states that had already passed laws banning the execution of the intellectually disabled. In fact, at the time, there was 18 of 38 death penalty states that already passed these laws. And several others had done so prior to a previous case, which was Penry versus Linnell. And the court found that this demonstrated a national consensus against the practice. Now, second, they found that professional and religious organizations overwhelmingly opposed such executions. Okay. And third, they found an international opinion also strongly condemned the practice. So beyond this consensus, the court's reasoning also hinged on the diminished culpability of intellectually disabled offenders. And the court explained that individuals with these disabilities, by definition, have significant limitations in intellectual functioning and adaptive behavior. And these limitations mean that they have a diminished capacity to understand and process information. They have less ability to understand the consequences of their actions. They are less able to control their impulses. They are less able to learn from experiences. And they're more susceptible to manipulation by others and to coercion during police interrogation, which could lead to false confessions. And they were also less able to assist their attorneys in their own defenses. So, given this diminished culpability, the court concluded that the death penalty was meant for the most morally culpable offenders. And it served neither a penological goal of retribution, which again they are less morally blameworthy, nor as deterrence, as they are less likely to be deterred by the threat of execution. So therefore, executing these individuals with these intellectual disabilities was deemed disproportionate and cruel and unusual. So the impact of Atkins versus Virginia was establishing a categorical ban on the execution of individuals with intellectual disabilities nationwide. And that significantly limited the application of the death penalty, ensuring that this ultimate punishment was reserved for those who were deemed to have the highest level of moral culpability. And the decision left it to the individual states to determine appropriate procedures for determining whether a defendant is intellectually disabled, which has led to ongoing litigation over diagnostic criteria and those evidentiary standards. But it also leads to another profound set of limitations, and that applies to juvenile offenders. And the court has also imposed categorical bans on the death penalty, and in some cases, even life without parole for juvenile offenders based on their age at the time of the crime. And these decisions reflect a growing understanding of adolescent brain development and culpability. And the first major case directly addressing this death penalty for juveniles was Roper versus Simmons. By the way, I apologize if you hear my grandbaby in the background. He's just having a good time. But so Roper versus Simmons. So Christopher Simmons was 17 years old when he committed murder in Missouri. And he planned and committed the murder of a woman with two younger accomplices. And after he turned 18, he was tried, convicted, and sentenced to death. And his case eventually reached the Supreme Court, arguing that executing someone who was a juvenile at the time of the crime violated the Eighth Amendment's prohibition against cruel and unusual punishment. So the question before the court was, does the Eighth Amendment's prohibition against cruel and unusual punishment forbid the execution of individuals who were under the age of 18 at the time they committed the capital crime? And the Supreme Court held that, yes, it does prohibit the execution of those individuals who were under the age of 18 at the time they committed a capital crime. And it found a national consensus against such executions, rendering them unconstitutional. And Justice Anthony Kennedy wrote for the majority and said that the court noted that there was an overwhelming consensus among the state legislatures against the juvenile death penalty. And it also looked to the international opinion, where the United States stood almost alone in permitting such executions. And the core of the court's reasoning, it did center, though, on the diminished culpability of juvenile offenders based on three factors. First was the lack of maturity and sense of responsibility. And this is where juveniles are generally more impulsive, irresponsible, and less mature than adults, making it harder for them to foresee the consequences of their actions. The second was the vulnerability to negative influences and peer pressure, where juveniles are more susceptible to peer pressure and external influences than adults, making them more likely to be involved in risky behavior. And then you have the transitory character of personality traits. And the character traits of juveniles are often not fully formed or fixed, meaning they have a greater capacity for rehabilitation and change than adults. So the court said, given this diminished culpability, they concluded that the death penalty meant for the most culpable offenders was a disproportionate punishment for juveniles. And they recognized, again, those penological goals of retribution and deterrence were not served by executing those with diminished moral responsibility. So the impact of this case was that Roper v. Simmons, it abolished the juvenile death penalty nationwide. It established 18 as a minimum age for capital punishment, which that is still greatly up for debate as well. But it based on, the age of the person at the time the crime was committed. And it was followed by a significant victory for juvenile justice reform, and dramatically limited the scope of the death penalty itself. But following Roper, the court then addressed the constitutionality of life sentences without parole for juveniles, starting with non homicide offenses in Graham versus Florida. So now let me just say that all the cases that I'm telling you about, intellectual disabilities and juveniles, these are all still relatively new. They happened in the 2000s. And Graham versus Florida was, I think, 2010. But so this case was Terrence Graham was 16 when he participated in an armed robbery. And he was charged with attempted armed robbery and battery. And he pleaded guilty and was sentenced to probation. And 6 months later, he violated his probation by committing a home invasion. And as a result of the probation violation, and his original offense, the trial judge revoked his probation and sentenced him to life in prison without the possibility of parole, which was mandatory under Florida law for certain repeat felony offenders. And this was for a non-homicide offense. Now, the issue before the court was, does the Eighth Amendment's prohibition against cruel and unusual punishment forbid a sentence of life imprisonment without parole for a juvenile offender who commits a non-homicide crime? And the Supreme Court held that yes, it does. When it comes to juvenile offenders to life without parole for non-homicide crimes, it found the sentences to be disproportionate and unconstitutional. So Justice Anthony Kennedy wrote for the majority, and they extended the reasoning that came from the Roper case regarding the diminished culpability of juveniles. And it emphasized that juvenile offenders, even for serious non-homicide crimes, have a greater capacity for rehabilitation and growth than the adults do. So a sentence of life without parole for a juvenile without any hope for release fails to account for these unique characteristics of youth. And the court stressed that the state must give the juvenile offenders some meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. Okay. So while the state's, penological interest in non-homicide crimes are important, they are not sufficient to justify extinguishing all hope of reform for a juvenile. So the court did not ban life sentences for all juvenile or for juveniles for non-homicide offenses, but it required that these sentences include a meaningful opportunity for release based on rehabilitation. So the impact here was that Graham versus Florida, it banned life without parole sentences for juveniles who committed non-homicide offenses, and it reinforced the principles that children are different for sentencing purposes and that their sentences must reflect their potential for rehabilitation. And this led to a review and resentencing of thousands of juvenile offenders that were previously serving those sentences. Now, the court then addressed life without parole sentences for even juvenile homicide offenders in Miller versus Alabama, also a 2000s. Actually, this was in 2012. So Evan Miller was 14 years old when he participated in a murder. It was in Alabama, along with another boy who was 16. They severely beat and burned a man to death. And Miller was charged with murder in the course of arson. And under the Alabama law, murder in the course of arson carried a mandatory sentence of life imprisonment without the possibility of parole. So the judge had no discretion to consider Miller's age or any other mitigating circumstances before imposing that sentence. So the question before the court was, does the Eighth Amendment's prohibition against cruel and unusual punishment forbid mandatory sentences of life imprisonment without parole for juvenile homicide offenders? And the Supreme Court said, yes, it absolutely does. These sentences are unconstitutional. So, Justice Alina Kagan wrote for the majority, and she said the court did not ban life without parole sentences for juvenile homicide offenders outright. Okay. But it ruled that they could not be mandatory. And it extended the reasoning from Roper and Graham about the unique characteristics of these juvenile offenders. They're immature, they're impulsive, they're vulnerable to these negative influences, and they carry a greater capacity for rehabilitation. And the court emphasized that when a sentencing scheme mandates life without parole for a juvenile without allowing any kind of judge or jury to consider the juvenile's age or other mitigating circumstances, like maybe the family's background or the nature of the participation in the crime, or even just the likelihood of rehabilitation, that it violates the Eighth Amendment. And the court stated that mandatory life without parole precludes consideration, of the chronological age and its hallmark features, and thereby it offends the principle of proportionality, which the Eighth Amendment demands. So it has to be a discretionary sentence. It has to be reserved for the rarest juvenile offenders whose crimes reflect irreparable corruption. Okay. So the impact here was that Miller versus Alabama significantly limited the use of life without parole sentences for juvenile homicide offenders by making them discretionary rather than mandatory. And that led to the resentencing hearings for thousands of juvenile offenders who had been automatically sentenced to life without parole in states with those mandatory laws. And it solidified the principle that youth matters when it comes to sentencing, even for serious crimes. And it requires individualized consideration of their culpability and their potential for reform. So, this case, along with Roper and Graham, it reshaped juvenile sentencing in the United States altogether. Now, the court did also impose limitations on applying the death penalty based on the nature of the offense. So, for instance, while the felony murder rule is generally constitutional, which is allowing a defendant to be found guilty of murder if a death occurs during the commission of such felonies, even if they did not directly intend or commit the felony or the killing, rather, the Supreme Court has significantly limited the application of the death penalty under the felony murder rule to those who killed, intended to kill, or who were major participants in a felony who acted with reckless indifference to human life. And again, it was to ensure that the death penalty is reserved for the most culpable individuals. Now, we talked a little bit about the felony murder rule, but let's shift gears for a second and talk about it as a general concept. And again, this is the rule, it's a legal doctrine that allows a person to be charged with murder if another person dies during the commission of certain dangerous felonies, even if the defendant does not intend to kill or directly cause the death. The intent to commit the underlying felony, which is robbery, arson, kidnapping, rape, burglary, that intent is now imputed as the malice portion for the required murder. So, for example, let's say you have three individuals. You have A, B, and C. Okay. And they plan and they commit a robbery. And A is the getaway driver. B and C go inside. And during the robbery, B shoots and kills a bank teller. Even though A, the driver, does not pull the trigger and may not have intended for anybody to die, under the felony murder rule, A, B, and C can all be charged with murder because the death occurred during the commission of a dangerous felony in which they were participating. This is because the possibility of, using a weapon and things like that does happen during the course of these types of crimes. Another example is, let's say that you have A who attempts to burglarize a house, and as he's fleeing, the homeowner suffers a heart attack and dies. Okay, so under this felony murder rule, A could still be potentially charged with murder, even though he didn't physically harm the homeowner or to intend their death. But because the death occurred, it was basically a direct result of the commission of that dangerous felony, which was the burglary. Now, while the felony murder rule itself is generally constitutional for imposing a murder conviction, the Supreme Court has placed very strict limits on when the death penalty can be applied to felony murder defendants. And they focus on the defendant's individual culpability. This means not everyone involved in a felony murder is eligible for the death penalty. So let's look at an example. So let's say that A acts as a lookout for a robbery, okay? And her accomplice, B, goes inside and unexpectedly shoots and kills the store clerk, all right? A is unarmed, did not intend for anyone to be killed, and was not a major participant in the violent aspects of the robbery, okay? Nor did they act with any kind of reckless indifference to human life. So under Supreme Court precedent, A could not be sentenced to death. Okay. So while they may still be convicted of felony murder, the Eighth Amendment is going to prohibit executing a defendant who did not personally commit the killing, did not intend to kill, and was not a major participant acting with reckless disregard to human life. But let's use another example. Let's say that A and B commit a robbery. Okay. And A is the inside guy and he's brandishing a weapon while B is standing outside, but clearly prepared to assist in any violence. And during the robbery, A shoots and kills a customer. B doesn't pull the trigger, but he was a major participant in the robbery and acted with reckless indifference to the extreme risk of human life that's posed by the armed robbery. So, under the Supreme Court precedents, B could be eligible for the death penalty, even though they were not the trigger man. Okay. They look at the role as a major participant in a felony combined with the reckless indifference to human life, meaning that B consciously disregarded a substantial and unjustifiable risk that a death would occur. And they could meet a higher culpability standard that is required for the capital punishment under the felony murder rule. But these examples, they illustrate that while the felony murder rule broadly allows for murder charges, the application of the death penalty itself under this rule is kind of narrowly confined to those individuals who, again, either kill, intended to kill, or were major participants in the felony and acted with extreme disregard for human life. Now, beyond the death penalty, the cruel and unusual punishment clause does also apply to prison conditions. And if you are in any kind of prison groups, you're probably just shaking your head right now and going, how is this not being like enforced all over? Because there's some serious issues with this. But nonetheless, we're going to talk about this in its purest form. And that is that the Eighth Amendment requires that prison officials provide humane conditions of confinement. So while conditions do not have to be comfortable, they need to not deprive inmates of basic human needs. So for an Eighth Amendment violation based on prison conditions, inmates have to show that the conditions objectively pose a substantial risk of harm to their health or safety, that the prison officials also acted with deliberate indifference to those risks, meaning that they knew of the serious risk and they disregarded it. And this is a high standards. So you're going to have where mere negligence is not enough. So last but not least, we have the Eighth Amendment's proportionality principle, which has a very limited application when it comes to the proportionality of sentences for non-capital cases. So for sentences that don't involve the death penalty, the Supreme Court gives great deference to legislative judgments about the appropriate sentences. So the court rarely finds that non-capital sentences to be cruel and unusual punishment unless they are considered grossly disproportionate to the crime. So this is a very high bar. And it means that even very long sentences for repeat offenders or serious, nonviolent crimes are going to generally be upheld. Now, let's quickly kind of broaden our scope and talk about that overarching concept of procedural due process as it applies throughout the criminal justice system. And we talked in a previous lecture about the due process clause as it appears in both the Fifth Amendment, which applies to the federal government, and the 14th Amendment, which applies to the states. And the core principle of procedural due process is that the government, when it seeks to deprive an individual of their life, liberty, or property, it has to provide fair procedures. Okay. So in the criminal context, life means the death penalty, and liberty refers to the incarceration or other significant restrictions on freedom. Now, in the criminal context, procedural due process generally requires you get notice of your charges. So the accused has to be informed of the specific crimes that they have that they allegedly committed. Okay, they have to have the opportunity to be heard and to present a defense, and that means that the accused has to have a meaningful opportunity to present their side of the story. They get to confront their witnesses and offer evidence. And this includes the right to a fair trial. And then they have the right to an impartial tribunal. So the judge and the jury, if they have one, has to be unbiased. You have the burden of proof. So in a criminal trial, the prosecution typically bears the burden of proving guilt beyond a reasonable doubt. And that's a very high standard that's rooted in due process. You have to have well, let me back up. So procedural due process is it's important at those key stages throughout the criminal justice process. So you have the pretrial, which is going to include your procedural protections in the preliminary hearings. Those are to determine if there's probable cause to hold a defendant. In the bail hearings, which is, to set the conditions for release. And then even at the grand jury proceedings, though, remember that the grand jury itself is not incorporated against the states, but the overall due process principles are still going to apply to state probable cause determinations. Now, with the trial, due process guarantees a fair trial. So it includes the right to discovery, which is the process by which, both sides are going to exchange information before the trial. Remember, this is the part where there's supposed to be no smoking gun. Each side is supposed to know what the other side is bringing to the table, because we don't want one of those, those gotcha moments. You have the rules of evidence, which are to ensure the reliability and fairness. And then you have proper jury instructions, which are to ensure the jury understands the law. And then you have post-conviction, which is where procedural due process also applies to stages after conviction, such as sentencing hearings, like ensuring, fairness in determining punishment, and then parole hearings in determining whether a prisoner should be released early. And a classic example of procedural due process in action in the criminal context is the right to exculpatory evidence. And this is a very important case that gets cited a lot. And it was established in Brady versus Maryland. So John Brady and his buddy Charles Boblet were charged with murder, and Brady admitted his involvement in the crime, but he claimed that Boblet was the actual killer. Now, before Brady's trial, the attorney requested access to all of Boblet's statements to the police, and the prosecution provided some of Boblet's statements, okay? But they withheld one in which Boblet confessed to the actual killing. Remember when I said they have to exchange all information? There should be no smoking gun. This would have been what would have gotten Brady off, right? But they withheld it. Brady was ultimately convicted and sentenced to death. Now, after his conviction, Brady's attorney discovered this withheld statement, and he appealed, arguing that his due process rights were violated. So the question before the court was, does the due process clause require the prosecution to disclose to the defense evidence that is favorable to the accused and material to guilt or punishment, even if it is not specifically requested? And the Supreme Court said, yes, the prosecution suppression of evidence that is favorable to the accused, which was requested by the defense, mind you, violated due process where the evidence was material to either guilt or punishment. And this became known as the Brady Rule. And Justice William O. Douglas wrote for the majority, and he said that the court reasoned that society wins not only when the guilty are convicted, but when the criminal trials are fair. And it held that the suppression by the prosecution of evidence that's favorable to an accused upon request violates due process where the evidence is material to either guilt or to punishment, regardless of the good faith or the bad faith of the prosecution. And evidence is considered material if there is a reasonable probability that the evidence has been disclosed to the defense. The result of the proceeding would have been different. Okay. And in this case, it would have. The Brady Rule creates a constitutional obligation on the part of the prosecutors to disclose this exculpatory evidence, and it prevents the trial by ambush or the conviction of innocent persons. And the impact here is huge, okay? Because Brady versus Maryland, it established the Brady Rule. And that is a cornerstone of criminal discovery and procedural due process. And it places a constitutional obligation on prosecutors to disclose all material that all material exculpatory evidence to the defense to ensure a fairer trial. So this rule is vital in preventing wrongful convictions and promoting the integrity of the criminal justice system. And really think about Brady and that whole concept of the outcome, because had they given this confession by Boblet, it definitely would have made the outcome very different. And it's a good example of this particular amendment and how it's supposed to give those safeguards for those who are going through the criminal justice system. It's supposed to be designed to ensure fairness, to prevent that arbitrary punishment and to limit that governmental overreach, which the prosecution in that case, violated. Because it's supposed to ensure that even the accused that is facing like the highest power of the state is going to retain the fundamental rights and access to justice. And remember that the interpretation of these rights is ongoing. The Supreme Court is constantly refining these principles, attempting to kind of seek to balance individual liberty against societal interest in safety and order, especially as new technologies and social challenges arise. But understanding these protections is absolutely fundamental for anybody who is involved in or is affected by the criminal justice system. And that's it for this one. Let me know if you have any questions. Bye.